Welcome everybody. So I'm just going to do some quick introductions to our speakers today before I hand over to them. So as you'll be aware, in the forum today we're going to be looking at mediation and also the National Planning Policy Framework. So in terms of our speakers, we have Stuart Lawrence, who is a qualified barrister, an adjudicator and an accredited mediator, and he's also the founder of Mediator Locator, a professional mediation services panel. So he'll be taking on some of the topic in relation to mediation, followed by my colleague Harnek Rahania, an associate in our construction team here at Sharps. And they will both be looking at mediation and the court's evolving view of mediation, as well as some of the practical tips for a successful mediation. And then we will hand over to Emir Thomas, who's a partner and parliamentary agent, and Emily Knowles, who's a managing associate in our planning and parliamentary team. And they'll be talking us through the changes that were brought into force in the December National Planning Policy Framework, and I think perhaps some further updates since then. So we will be very much looking forward to that. But I will let Stuart kick us off with the mediation piece.
Thank you very much, Rachel. Appreciate that. Good morning to everybody, and thank you to Sharp Pritchard for allowing me to speak this morning. As Rachel mentioned, I'm Stuart Lawrence. I'm from Mediator Locator, which is a mediation platform. I've got a background in construction as well. I spent many of my years working for the Bouygues Group as head of legal for one of their large subsidiaries. So I've seen quite a lot of construction disputes over the years. Melissa, if you could move on to the next slide, I'd be grateful. Just a very quick bit of information about who we are. We're a free mediation referral service. We currently partner with 11 law firms, and we're talking to a few others to increase our footprint. One of our partners is Sharp Pritchard, which I'm delighted about. We've currently got 27 skilled, legally qualified mediators, most at partner level. As you can see from the map there, we have national coverage and we have expertise across all sectors. All of our mediators are often leaders in their fields as well, so there is a great deal of depth and experience. We've got a primary panel, which is for higher value, more complex disputes. And then we have a set value panel, which is for disputes, smaller disputes up to £50,000 in value. And they come with fixed fees. So that offers a very cost-effective way to resolve disputes. And we offer both in-person and virtual mediation. So if you'll forgive me the short sales pitch, I'll now move on to the topic at hand, which is mediation. What I'd like to do this morning is give you a quick overview of mediation in the construction sector, talk about key developments impacting mediation, and then focus on some of the CPR rules and amendments which came in very recently. Next slide, please, Melissa. So as many of you have probably been involved in many disputes in construction, and construction is a pretty litigious environment with a lot of challenges. And as I'm sure you'll appreciate, you've probably never been in a dispute where you've got an absolute slam dunk of a case. There's always difficulties on both sides. Sometimes it's the documentation that's not up to standard. Sometimes there's verbal instructions which move away from the contract, and you always have issues around scope and so forth, delay and disruption, and often a lot of issues around cost. And if you are in that situation and you need to try and resolve it through dispute resolution, you've got a sort of suite of options from mediation to adjudication, arbitration, and litigation. And, you know, often you'll see in the contracts that you're familiar with the dispute resolution clause, which will probably say something along the lines of, you talk to each other. If you can't get a resolution, then you escalate it to a senior member, possibly the CEO of the business. And then after that, you have more formal options. You can mediate, which is a voluntary process, which I'm a big advocate and fan of, and I'll explain why in a moment. Or you can adjudicate, which I imagine a lot of you are probably quite familiar with, and probably arbitration less likely, and then ultimately maybe litigation. But you've probably been in a situation where you have a good case and you've been to a lawyer and they've looked it over and they've said, okay, well, the best scenario here is that you're going to win, and I would give you probably a 70% chance of success. That's probably the highest you'll ever get from a lawyer, which I would suggest is only 20% higher than flipping a coin. So if you go into resolution to sort of formal, determinative formal resolution, it's a real gamble. Mediation, in contrast, in my view, allows you to preserve control of the process. There's a very high chance of success, something in the order of 90% of cases that mediate settle. It's much cheaper, it's much quicker, it's much less stressful, and it's more efficient. And I think one of the key factors in construction is you can preserve relationships. Once you issue a notice to adjudicate or a litigation claim, pretty much the relationship's destroyed and you'll never darken each other's doors again. And that's not always a good way to operate in construction. So there is the opportunity to preserve relationships. There's the opportunity for increasing roles in mediation. Sorry, Melissa, we've jumped around. If you could go back to the next slide, next one, please. Lovely, thank you. There's the opportunity for dealing with complex disputes. I mean, obviously in construction, you may have a client, you may have a main contractor, and you may have a subcontractor or indeed a few subcontractors. The beauty of mediation is it allows multi-party resolution. And there's been a lot of changes in recent case law and legislation. So if we can move on. So mediation is encouraged in the standard CPR, the Civil Procedure Rules, and in the overriding objective, it says that mediation should be considered, as indeed other forms of ADR should be considered, that's alternative dispute resolution. But historically, mediation was to be considered, but the courts were hesitant to impose real sanctions. That's something that's starting to change. And there was a varying degree of engagement across the industry. And personally, I would say construction is one of the areas where mediation is substantially underused. And I think there's perhaps a perceived inefficiency or inefficacy of using mediation, and it's seen too much as a compromise. But I would hopefully dispel you from that. Next slide, please. So what happened? Back in 2024, 1st of October, the Civil Procedure Rules Amendment number 3 came in. And what that is designed to do is to push people far more into mediation. And the beauty of that from those people who propose mediation and advocate it is that it actually finally comes with some teeth. And the courts have the power to push mediation and impose sanctions on costs if you don't mediate. So there is actually a real drive towards mediation, and there is some sanction behind it if people don't properly engage. And the protocol, the pre-action protocol is now reinforced by this rule change. And it's starting to have a bigger impact on legal professionals and their obligations, because a competent lawyer will also now be saying to people, you need to give proper consideration to mediation, and it can't just be transitory, it's got to be proper consideration. And one of the mediators on our panel is a deputy district judge, and he said to me a little while ago that perhaps 5 years ago he would be saying things like parties should consider mediation, and in a trial would say, have you given, or a pre-action matter, have you given consideration to mediation? And everybody would sort of harumph and go, oh yes, it's actually been proper consideration. He said, now the judicial position is, I need to see evidence of that. I need to see that you've given it proper consideration. So it is definitely happening. And the case of Churchill and Merthyr Tydfil swept away restrictions around mediation. There was a point that the court raised in the past about whether mediation would making mediation mandatory would stop people having a fair trial. And that existed for probably 15 to 20 years, but the case of Merthyr Tydfil and Churchill swept that away. So you can mandate mediation and still preserve the right to a free trial. Next slide, please. So what's happened? Since the CPR rules have came into effect in October 2023, there's been an increased use of increased use of mediation in construction disputes. And the court's actively penalising any unreasonable and refusals by the parties to mediate. And that's definitely happening. I've seen a few referrals come through to me where High Court matters have been stayed and the judge has ordered the parties to mediate. So it's definitely happening. In contracts, you're seeing more and more move towards having early mediation provisions. And early mediation is the best mediation because it gives you the best chance of resolution. And then you may be aware that there was a case last year, Superdry Manchester City Group. So this was to do with the Superdry emblems on the football shirts of the Manchester City players. Superdry in this scenario was the zero alcohol provider. But of course, you're probably familiar with the textiles clothing manufacturer Superdry. And they felt that the Superdry image on the shirt of the Man City players was infringing on their intellectual property and took a claim before the High Court. Superdry made overtures that they were keen to mediate, and the Manchester City Group said absolutely not. Went to court, and the judge, in an interlocutory or an early matter, said, I'm sorry, Manchester City Group, I'm going to order you to mediate. This was the first time that a court had actually ordered a recalcitrant party to mediate. And the good news is that 3 months later, the case settled. Because mediation is confidential, I don't know the outcome, but I'm sure there was a financial payment, but also mediation gives the opportunity to have more inventive settlements, more creative settlements, whereas the court would have just made an order in damages or possibly an injunction to not use the shirt. So I think that's a key case that is driving people much more towards mediation. Next slide, please. So the summary and takeaways from this is mediation is definitely on the up and it's here to stay. And you would be foolish not to give it proper consideration, because if you fail to do so, there is every chance the court could penalise you in costs or stay your matter and order you to mediate. So you have to mediate. Evolving role of mediation in construction, I personally think it's massively underused. In my career resolving disputes, I'm sorry to say I didn't use mediation as much as I wish I had have done. And I think it's quicker, cheaper, far less stressful, and I think you should definitely use it. And if you need a mediator, I have an excellent panel of people, including Rachel from Sharp Pritchard, who's on my panel. So do give us a shout. Mediatorlocator.com is the website address, and we have a presence on LinkedIn where we publish articles and information about mediation. That was a very quick canter through, because I know I was only had 10 minutes, but if anybody has any quick questions, or if they want to save them to the end, whatever Rachel prefers, I'm happy to answer them now or deal with them at the end. Thank you very much, and I hope that was helpful.
Thank you, Stuart. So if there are any questions, we'll pick those up at the end. So we'll hand over to Harnik.
Good morning, everyone. In this part of the presentation, we'll turn to some practical tips that may assist you with any future mediations. Next slide, please. So our first tip is to choose the right mediator. Now, your contract may specify a mediator or an appointing body which you must use, but if it doesn't, you should try to find a mediator who is good at building rapport with the parties, takes time to listen to the parties and understand their concerns, and works hard to reach a deal. The mediator should ideally have the right background and expertise to understand the details of your case. A good mediator should apply gentle pressure to the parties, and particularly later on in the day, where one of the parties' position perhaps fails to recognise risk. And that's one of the reasons why it's helpful to have a mediator who has the expertise to understand the dispute. And one of the best ways to find the right mediator is to simply ask colleagues or your legal advisors if there's anyone that they have used and would recommend. And word of mouth is quite important to this in that regard. Next slide, please. So our next tip is to mediate at the right time. Not all cases benefit from an early mediation. For example, if you have a complex case or if it involves a lot of expert evidence, you may need to go through a few turns of correspondence and evidence exchange before the matter is ready for a successful mediation. And from my own experience, I had a mediation once where it was clear the other side had not engaged with our claim or the complex expert report that we had issued to them. And because of this, the mediation wasn't successful. The parties were simply too far apart at that stage, and it was not until several months later, when the other side had properly engaged with our expert evidence, instructed their own expert, and after a few more turns of correspondence, that they realised their weaknesses and the matter finally settled. I do believe that the mediation, that if it had taken place later than it did, the chances of reaching a reasonable settlement would have been much higher. Now, that being said, it doesn't mean that you have to leave mediation to a late stage, but we recommend waiting until all parties are truly engaged in the dispute and have considered their positions, likely after expert reports have been exchanged and both sides are starting to feel the pain of incurring costs to proceed with the dispute. Alternatively, you may consider mediating only certain issues early on, thereby narrowing any points left for litigation. Next slide, please. Our next tip is to make sure you have effectively prepared for the mediation. Whilst it may sound obvious, this is key. Prior to the mediation, you should familiarise yourself with the case, know the quantum of your claim, know the strengths of your case. You should understand where your weaknesses are. You should consider what both a good and an acceptable outcome to the mediation looks like for you. Consider what offers you're willing to make. What is your bottom line? What is your alternative if the mediation is unsuccessful? How long is the dispute going to last? How much is it going to cost? How will it impact your day-to-day operations? Can you handle the stress, the uncertainty, the required resource allocation, and everything else that goes along with it? You can then measure these against any potential deal on the table and decide if it makes sense to settle or not. Next slide, please. Attendees. You should have someone at the mediation with the necessary authority to settle. Many mediators will insist on this in the terms of their mediation agreements. If it looks as though a deal can be reached on the day, it can be incredibly disruptive if one side then says that any in-principle agreement will require separate approval, which may or may not be given. If the person with authority to settle is at the mediation, they'll be privy to all the conversations and the back and forth between the parties, and they'll understand how the parties have reached the settlement position that they have. If they are not present, it will be hard to try and relay everything back to them and to get them to understand how the parties have gotten to that position. In addition to bringing somebody with authority to settle, you should also consider who else should attend. Think about what the other party may want in terms of process and solution. For example, a party may want to talk in detail about something specific, such as the technical aspect of a claim. And so you should have the right person there to do that. That may mean having experts that you have instructed to attend the mediation, which is actually quite common now. Next slide, please. Next, consider your behavior at the mediation. The first thing to mention is that you should not spring any surprises on the other side on the day, as that will definitely delay reaching any settlement. You should focus on practical solutions, not the law or each party's legal position. You should focus on whether it's possible to reach a mutually beneficial outcome. You do also have a say in how the day unfolds, so we suggest using the initial joint session to suggest a structure for the day. Next slide, please. So, concessions and making the first offer. Mediation requires the parties to work together to reach a compromise, and neither party will come away with 100% of what they want. You should break the dispute down into elements that you can compromise on and elements that you can't. If you are willing to concede something and you take that step towards the other side, this can go a long way to progressing negotiations. Making an early concession, even if it's of little importance to you, can help the other side save face and encourage settlement. You may also want to consider making the first offer, as this can present a tactical advantage and can have an anchoring effect for further discussions. It's a sign that you are serious about reaching a deal, and if the other side, if the offer is reasonable and well explained, you're more likely to receive a counter offer that is also reasonable from the other side. Offers should therefore be credible and accompanied by a rationale, ideally. However, if the offer is too low, it can alienate the other side and can be seen as insulting. So, for example, I had a mediation last year where one party came in with an offer that was essentially the same as an earlier offer that they had made, which had been rejected already. The offer was in the low millions, where the other side believed that they were entitled to tens of millions. The party was not willing to move from that figure at all, and the other side thought that the offer was insulting, and because of that, they refused to even give a counteroffer. Needless to say, that was the end of the mediation. Next slide, please. Emotions. Now, even in commercial disputes, emotions and feelings are involved. The people who have been dealing with the dispute on a day-to-day basis are human and can build up feelings of anger or being aggrieved. Letting the parties have their say on how they are feeling and why can give the participants a sense of catharsis, which can help them move past it and towards settlement. But this comes with a warning that you shouldn't fixate on the anger and you should be prepared to move on from it. Similarly, addressing and empathizing with the other party's feelings and grievances will also help both sides move towards a resolution. Next slide, please. So finally, the settlement agreement. If a settlement is agreed, try to get it documented and signed on the day of the mediation if possible. This prevents further protracted and unnecessary negotiations on the terms of the settlement agreement where things can go awry. Prepare a draft in advance of the mediation and, as discussed earlier, ensure those with authority to sign are present at the mediation. In the agreement, you should be very clear on what you are and are not settling, especially in relation to future claims. Thank you all for your time.
Thank you, Harnik. So we will hand over to Emily now.
Hi everyone. Thanks Rachel for inviting us to speak. So today I'm just going to be walking you through some of the key updates introduced by the Labour government in the National Planning Policy Framework, or the NPPF, from December 2024. So next slide, please. And again, sorry. So as I'm sure most of you are aware, the government has set really ambitious targets in relation to housing delivery. So, for example, it aims to approve 1.5 million new homes during this parliament and grant development consent to over 150 major infrastructure projects. And those are big numbers with real implications for real people, including developers, communities, and planning authorities. Since taking office in July last year, the government has framed its many planning announcements around meeting these targets and accelerating construction in order to get Britain building. And this really provides the background and the context of the changes made to the NPPF. Before I move on, I just want to touch on and acknowledge the spring statement that took place yesterday. So less than 5 months since the government's first budget, rising borrowing costs and urgent defence spending has really reshaped the fiscal outlook for that statement. But whilst sort of welfare and Whitehall budget cuts dominated politically, the key positive for Rachel Reeves was the Office for Budget Responsibility's appraisal of the government's planning reform and house building plans. So according to the OBR, changes to the NPPF, including the measures we're going to look at today, will result in house building rising to its highest level in over 40 years. They've assessed that changes to the NPPF alone will place the government on track to build an extra 1.3 million homes and deliver a 0.2% boost to UK GDP by 2029, 2030. So we're really interested to read a little bit more about that in the coming weeks and just keep that assessment under close review. But that's just a headline for you. Next slide, please. So quick reminder as to how the NPPF operates. It sets out the national planning policies for England, and local policies in local plans must comply with those national policies. The government launched a consultation on NPPF reform soon after taking power, and the updated NPPF was published on the 12th of December 2024. So for decision making, those new policies took effect immediately as material considerations, so when determining planning applications. And for plan making, the updated NPPF applies from the 12th of March, both of those subject to some sort of small exceptions. One interesting point just to flag is that paragraph 243 of the December NPPF hints at potential planning freedoms and flexibilities in certain areas to facilitate increased housing delivery. But I'm not aware of that there's any detail on what that means in practice, so we'll have to keep that one under review. Next slide, please. So a couple of headlines to do with new housing targets. Under the December 2023 NPPF, the last NPPF of the Tory government, the standard method for calculating housing need was made merely an advisory starting point, and local authorities were given more flexibility in setting those housing targets. That NPPF also removed the requirement for a 5-year land supply. This has been reversed by the 2024 NPPF. Housing targets are mandatory again, and LPAs have to demonstrate, again, a 5-year housing land supply. So this is undoubtedly going to have an impact on the construction industry. Local plans must demonstrate a robust pipeline of sites to be found sound by the planning inspectorate. And more importantly, a lack of a 5-year housing land supply could trigger the presumption in favour of sustainable development when dealing with an application, which creates opportunities for developers and landowners in areas where targets aren't being met. Headline 2 is that there's a new standard method. This seeks to establish higher but more balanced targets for housing. So the standard method, which is the method used for calculating local housing need, has been revised, and local planning authorities must now base their targets on 0.8% of their current housing stock. And this, the government says, will provide a more predictable and stable approach. At the same time, the government has made changes to the affordability adjustments. So affordability thresholds have been raised from 4 times to 5 times median earnings, potentially lowering overall housing targets for some authorities in more affordable areas. But to counterbalance this and ensure that targets remain sufficiently ambitious in line with the government's intention, that the affordability multiplier has increased from 0.6 to 0.95. If you don't understand those figures in the way that I don't understand them, which is fine, they're all a little bit high tech for sort of before 9 a.m. on a Thursday morning. The headline is that the changes redistribute housing targets, directing more development to areas with affordability pressures, but preventing overinflated targets in affordable regions. So that's going to have a practical impact, it must do, on where we start to see planning applications being submitted and where development opportunities will lie. But if you want a little bit more information on the standard method, feel free to ask any questions afterwards. Next slide, please. The next major change relates to the green belt and introduction of the grey belt. So headline 1 is that there are changes to the Greenbelt review. So previously, there was no obligation to review Greenbelt boundaries, but now local planning authorities must do so where exceptional circumstances exist, such as an inability to meet housing or commercial development needs. However, following that review, if a review or a change to the boundary would undermine Greenbelt purposes, then no changes need to be made. And this does create uncertainty as to whether local planning authorities are going to embrace this flexibility, or where they've been traditionally resistant to amendments, will simply use this as a way to continue to do so. Headline 2 is the introduction of the grey belt, a new concept and a new subcategory of greenbelt, which includes previously developed land or land that no longer strongly contributes to greenbelt purposes, such as preventing urban sprawl or preserving historic town settings. In order for development on the grey belt to be permissible, it must then comply with PPG guidance, which states that it must not fundamentally undermine greenbelt purposes. There must be a demonstrable unmet need for proposed development. The site should be in a sustainable location, such as with good transport links, and the development must comply with the golden rules. And those golden rules have been introduced under paragraph 156 and require that developments contribute to affordable housing, either in line with local policies, but plus 15% up to a cap of 50%. So essentially 50% affordable housing on the green belt or grey belt. Make contributions to infrastructure improvements, local or national, and create or enhance publicly accessible green space. And a development which complies with those rules will be given significant weight in favour of approval. But, you know, it remains to be seen whether this is going to encourage building on the green belt. The burden of contributions could really create quite big viability challenges, and the subjective nature of grey belt definition, you know, that sort of will it strongly contribute to the green belt purposes? That again creates some sort of subjectivity, which could lead to inconsistent outcomes across local planning authorities. So we do expect to see more proposed development in the green belt and the grey belt, but and there certainly have been a lot of applications over the last few months, but that doesn't automatically mean that development on the green belt will be acceptable and approved by local authorities. Next slide, please. The final point I just want to address is one that actually doesn't appear in the NPPF, so I'm taking a little bit of liberties here, but it's something that the government has mentioned alongside the NPPF, and that is their intentions for tackling slow build-out rates. So the problem is that, you know, granting permission doesn't guarantee delivery, as I'm sure we all know. And since 2007, over 1.4 million homes with planning permission remain unbuilt. So often, developers may not want to build because they're waiting for rising land values and they want to limit housing supply to maintain higher prices, which makes sense. But that obviously has an impact on delivery. So the government's response is going to be to rely on the provisions that already exist in the Levelling Up and Regeneration Act 2023. And there are provisions there which are not yet in force or fully in force through regulations. So Section 111 requires that developers submit development commencement notices and annual progress reports to local planning authorities, which will track housing delivery. And Section 113 allows authorities to decline applications from developers who have a poor track record of building out in their local area. So I just wanted to flag those. There's no confirmed timeline for those provisions taking effect, and there'll be need to be detail in secondary legislation. But it's just a flag. I think it's really important for the construction industry to be aware that the government does have an intention to address slow build-out rates, and that is going to have a practical impact. So that's the end of my section, and I'll hand over to Emir.
Well, thank you very much, Emily, and good morning, everyone. I'm talking about some of the other announcements that have been made since December 2024. There have been a couple this week already. Just 2 days ago, the government announced its Affordable Homes programme, and it also said that the long-term housing strategy would be published shortly. More significantly, however, is the recent introduction in Parliament of the Planning and Infrastructure Bill, which was preceded by several working papers and consultation documents, which some of you might well have responded to. Now, I heard someone say recently that those whom the gods would destroy, they first make responsible for planning reform. And one of the reasons for this is that with planning reform, you have the opportunity to please few people, but upset many. Developers upset because proposals aren't liberalising the regime enough. Local authorities upset because they're being asked to do more and more with fewer resources. And of course, voters upset, feared by the prospect of a housing development in the front garden and a nuclear reactor in the back garden because of the way that certain proposals are reported in the press. Now, what we're going to focus on today is something that Emily has touched on, and namely the proposal in the Planning and Infrastructure Bill to fast-track 150 planning decisions on major economic infrastructure projects by the end of this Parliament. And one of the ways they propose to do this is to amend the regime which governs nationally significant infrastructure projects, or NSIPs. Now, as you'll be aware, NSIPs are governed by the Planning Act 2008, and which provides a centralised regime for dealing with big infrastructure projects. So big highways projects, the delivery of airports, nuclear power stations, solar farms, wind farms, and the super sewer under the Thames was also delivered under that regime. Now, the regime was introduced in 2008 because it was taking so long for big infrastructure projects to be delivered in this country. And the most notorious example was Heathrow Terminal 5, which took 8 years from application to final consent, to the Sizewell B nuclear reactor, which took 7 years to follow the corresponding path. The NSIP regime, however, brings in a one-stop shop. You can get all, more or less, of your consents in a single document. And what's more, in order to provide certainty in terms of timing for investors, the regime includes certain fixed timetables for certain parts of the application process. So they did away with the inquiry. There's no inquiry in NSIPs, and they brought in an examination. And they also said the examination must be completed within 6 months. Following the examination, the examiners have 3 months to prepare a recommendation and a report. And then following that, the Secretary of State has 3 months to make a decision. And initially, the system worked incredibly well indeed. So in 2012, from application to consent, it was taking on average 2 years and 6 months. Fast forward to 2021, and it's taking 4 years and 2 months. Things have got slower ever since. There are three real reasons for this. One, owing to the nature of the examination, which is primarily a written process rather than, say, a process involving lots of hearings or a single hearing, more and more documents are being produced, and the documents are getting larger and larger. By the end of the examination, not all of the issues which are raised in the documents have been settled, and these then have to be dealt with by the Secretary of State at decision stage, and that's leading to the Secretary of State extending time limit from 3 months to longer for determining applications. The Lower Thames Crossing, which was granted consent earlier this week, that determination period was extended by over a year. In addition to this, there has been a growing appetite for litigation in this area. Previously, in the early years of the regime, there wasn't much litigation at all. One of the reasons for this was that because every project was supported by a robust policy. These robust policies, called national policy statements, were meant to be reviewed every 5 years. That didn't happen, and the absence of an up-to-date policy meant that there was a window for litigants to challenge decisions, and that has led to significant delays to the commencement of several projects. So if we focus on this slide, and the government is bringing forward 3 changes which it proposes will help speed up the delivery of these big and important infrastructure projects. Namely, reviewing NPSs, adding some flexibility into the regime, and then reducing the ability to challenge decisions. And if we move to the next slide, please. The NPS is the cornerstone of this regime. It sets out the need for the project, and it also sets out clear policy tests for each project to be consented. The NPS is subject to parliamentary scrutiny. It is subject to public consultation. It is subject to habitats regulation assessment and appraisals of sustainability. It's a very robust document. However, as I mentioned, several of these are now significantly out of date. The one for wastewater, more than 10 years out of date. The one for hazardous waste, even longer than that. So what the bill does, it basically says that there must be a full review, and if necessary, an update of each NPS every 5 years from the date on which the provision will come into force. That hopefully then will reduce the opportunity challenge. It will provide that robust policy background for each type of project, and will hopefully get things built. If we move to the next slide, please. An NSIP is an NSIP is an NSIP. The Act provides that if a development exceeds certain thresholds or criteria, then they must be determined under the Planning Act regime. However, certain developers, mainly those of solar farms, have come forward and said that they consider this as to be too inflexible. One of the reasons for this is that if a solar developer has gone away and acquired all of the land that it needs to bring forward the development, and the local planning authority has pro-solar policies in its area, then the developer considers that regardless of the size of the proposal, then it would be quicker to follow a different regime, the country planning regime, rather than the Planning Act regime. So what the bill does is include the ability the Secretary of State to direct the disapplication that a certain development, even though it crosses the NSIP threshold, should be delivered as an NSIP. It can use another regime instead. So hopefully that will deliver flexibility and also speed. The final change is the one that's probably generated most interest. And if we move to the next slide, please. And that's the ability to reduce challenges by judicial review. Now, the Sizewell C NSIP, which was granted consent in 2022, that it was challenged. And at first instance, the High Court said on paper that it was totally without merit. It then followed a substantive hearing where the judge said it was totally without merit. The Court of Appeal said it was totally without merit, and then the Supreme Court said it was totally without merit, and the challenge was eventually dismissed. That process took longer than it took for the application for the NSIP to be submitted and eventually determined by the Secretary of State. So the proposed change here is that if an application is made to challenge an NSIP, there will not be a permission stage on paper. Instead, there will be an oral hearing. And if at that oral hearing, the court determines that the application is totally without merit, then that will be the end of the story. There will be no further opportunity to challenge or appeal. The one-stop shop for that type of hearing. I'm not convinced that this will speed things up, and I don't think it's particularly key to local authorities, because in my experience, when local authorities have challenged NSIPs, there hasn't been a single instance of such a challenge being considered totally without merit. So this is really to deal with mischievous litigants in person who crowdfund the litigation. But we'll have to wait and see whether this will have the effect and whether it will help deliver those 150 major infrastructure projects. If you'd like to hear more about the bill, and there's lots in the bill, then Emily and I and other colleagues are doing a short talk on it on the 2nd of April. I'll put a link in the chat. Thank you.
Thank you, Emir. And I like the reference to mischievous litigants. That was my favourite of this morning. So I think that's about time up, but if anyone has any questions, thank you for sharing that, Emir. If anyone does have any questions regarding the topics or anything specific for any of the speakers that joined us this morning, please do drop us a line. We'll be happy to pick those up after the session. So that just leaves me to say thank you to all of the speakers, Stuart, Harnek, Emir and Emily, and thank you to all of you for joining us this morning. I hope you have a lovely day.